Well, good morning, everybody. Thank you very much for joining us this morning. My name is Kirsty Varley and I'm a partner and a higher courts advocate in the housing litigation team. And today's the final session that I'm going to be running in our general topic of mental health and litigation that we've done over the last year. And all of our sessions have been really incredibly well attended, and today's I can see is no exception. So on behalf of Forbes and myself personally, I just wanted to thank everybody very much for the support. We're currently looking at and working on a new programme of training for 2023. And from the conversations that we've already had, this promises to be just as exciting and innovative as this last year has been. So please keep an eye out for announcements about it. And we're looking to launch that in April of this year. So moving back to today's session, well, as I say, we've looked at mental health really throughout all stages of litigation and looked at some specific mental health conditions in more detail, some of those that we've seen in cases that we've been coming across recently. And so it's perhaps fitting that our last session of this programme focuses on what's usually the last part of litigation, namely giving evidence, trials and vulnerable witnesses. Just to note, I've deliberately left time at the end of this session for questions and for people to share experiences, best practice, etc. As I know that this is a very interesting topic. So I'm sure you'll see the Q&A function is open and the chat function is open as well. I'm proposing to get through the slides, and then if anybody wants to put anything in the Q&A function, I will happily go through those questions. And if you'd like to share experience and best practice as well, that would be much appreciated. So making a start, everybody really, I think, has their own perception of what vulnerable and vulnerability means. And if we're going to look at vulnerable parties and witnesses in litigation, firstly, we need to have an understanding of what vulnerable means for these purposes and in this context in court proceedings. And vulnerability is defined in Practice Direction 1A of the Civil Procedure Rules at paragraph 4. And the meaning of vulnerability there is given in relation to someone's age, potential immaturity or lack of understanding, their communication or language difficulties, that could include literacy, their physical disability or impairment or any particular health condition that might affect them, any mental health condition or significant impairment of any aspect of the person's intelligence or the social functioning, and that would include any learning difficulties. The practice direction also goes on to say that vulnerability can also relate to the impact on the person giving evidence of the subject matter or the facts that are relevant to the case. So a person may not be vulnerable in certain circumstances, but when talking about a particularly traumatic event that they've witnessed or in the circumstances of that case, the vulnerability could arise. Vulnerability could relate to the person's relationship with a party or a witness in proceedings, and the examples given, for example, where there's a sexual assault or domestic abuse, or where there's some intimidation involved. And then finally, and this is really the catch-all, which I'm going to come on to, any social, domestic or cultural circumstances that would make a witness particularly vulnerable. And really the final point on the slide is deliberately wide, I would suggest, because it allows not just the court, but also the parties. And if you as the housing provider, as the claimant, have access to all sorts of different types of personal information, then this would allow you to make whatever allowances that you think are appropriate to address any known or potential vulnerabilities of witnesses. So for example, where you might undertake an Equality Act review in proceedings, or where you're thinking about issuing proceedings, I'd suggest that it'd be good practice here to undertake a similar Equality Act / vulnerability review, bearing in mind all of the factors that the court has suggested here should be considered. I'd also advise that, as with any Equality Act considerations, that any vulnerabilities kept under review each and every time that you receive new information about the person in question. So when you're undertaking the review, whether it's an Equality Act review and or a vulnerability review, you need to consider the following, and this again is set out in the civil procedure rules. So you have to consider whether the factors are going to adversely affect the ability of the party or the witness to take part in proceedings and give evidence. And when you're looking at this, the court has to consider the person's ability to understand proceedings and also what their role in proceedings is. The person needs to be able to express themselves throughout the proceedings appropriately, and it needs to be able to put their evidence before the court. The person also needs to be able to respond to or comply with any request of the court, or do so in a timely manner. So you might here be thinking of compliance with directions and the person's ability to do that, whether it's filing witness evidence, etc. The person also has to be able to instruct the representatives, if they have any, before, during and after the hearing. And then finally, the person has to be able to actually attend any hearing. And I found that quite interesting, that even hearing attendance is included, and this could be for a number of reasons. And this reminded me of one particular case where I had, this was a defendant, not one of our witnesses, but the defendant on a possession claim, who had severe agoraphobia, and it made her too vulnerable to attend the court proceedings in person. So really, for this type of hearing, a hybrid hearing, so that's where the defendant's attendance could be permitted remotely, whether that be by telephone or CVP, a secure video link, etc., should be considered. And again, I'd advise that you review any circumstances whenever new or updated information is received, to look at the impact of any potential vulnerabilities on anybody who's involved in the proceedings. So when it becomes clear that there's vulnerability, and it needs to be considered by the parties and the court, and there are a number of things that the court will take into account, and the court will invariably set directions to manage how any adjustments need to be made in the way that evidence is given, or even in the way that the hearing's to be concluded. And so that may look at the nature and extent of the evidence that's given, the conduct of advocates and other parties in respect of the evidence of that person and towards that person, whether there are any special measures that need to be put in place for the person, and we'll come on to that in the next slide or two, whether there's any duty or power of the court under any enactment or its inherent jurisdiction to prohibit, limit or modify cross-examination of or by a vulnerable witness, or to appoint a legal representative to conduct a cross-examination. So we're really looking at things, particularly under the Equality Act, not exclusively, but those considerations will all come into play here. So as I mentioned, special measures, these are the measures that can be put into place to assist a vulnerable witness to give evidence. These are known as special measures, and there isn't really a definite list of them. These are just examples, and the idea is really that any measures that put into place should be as flexible as possible, depending upon the needs of the witness. So special measures can, for example, prevent a party or a witness from seeing another party or a witness by using screens. Special measures can allow a party or a witness to give evidence remotely by video conference, and we just touched on the agoraphobic defendant, so they were permitted to give evidence remotely. Hearing a party or a witness's evidence in private, if that is deemed to be appropriate. The court can order that advocates dispense with the wearing of wigs and gowns if that is going to assist a party to give evidence. The court can admit pre-recorded video evidence in some circumstances. It can also permit the questioning of a party or a witness through an intermediary. And it can also permit using a device or any other aid to help a party or a witness communicate. And I had another case once where a witness had a hearing impairment, And so the judge, all of the witnesses and the advocate, once we'd gauged the extent of the hearing impairments on this particular person, everybody was instructed to speak slowly and loudly and at a volume that the witness confirmed that they could hear. And the judge ensured that after each question had been put to them, the judge ensured whether the witness had heard it and understood it, and they were asked to repeat the question before being expected to answer. And that same process was undertaken in relation to any follow-up questions, any cross-examination, etc. And this allowed the witness to give their evidence without any obstacles, and really give their evidence in the same way that other witnesses without the hearing impairment were able to do. That obviously added to the time estimate, and so that just had to be factored in, and that was the way the court dealt with that particular scenario. And I had another case where a witness was wheelchair bound, and again the court changed the listing of the hearing to a larger courtroom, so this allowed the witness proper unfettered access to and from the courtroom without any sort of indignity or embarrassment of having to be taken out of a wheelchair, etc. So again, these are things that really should be built in at direction stage once you're aware of them, and then the court will do their utmost to accommodate. So the focus so far on the slides has been on vulnerable witnesses. Obviously, we have to be mindful of vulnerable defendants as well in proceedings. And we already suggested that reviewing the vulnerability of witnesses is vital. Well, it's at least as vital, if not more so, when you're considering defendants. So any existing vulnerabilities really should be picked up before litigation. Obviously, that depends on the information that you as a housing providers have on your house file. I appreciate you don't always get the full extent of somebody's medical history, etc. You consider the information that you've got in any Equality Act reviews and your vulnerability reviews, and then upon receipt of any medical evidence, GP's reports, psychiatric reports, etc., you'll be looking at it again, and hopefully it'll be raised at any directions hearings, particularly if that person is represented when trial dates are listed, so that some of the examples that I've given just now could be taken into account. For example, larger courtroom needed, extra time needed, those sorts of things. And so the measures and safeguards that apply to victims and witnesses obviously apply to vulnerable defendants. And the Equality and Human Rights Commission issued some guidance in March 2020, and that's called Inclusive Justice, if anybody of you want to look it up. And this report focuses on access to justice for criminal proceedings, but having read it, I would say that many of the elements are applicable and very useful when looking at civil proceedings as well. And this report focuses on whether a defendant can participate effectively in proceedings. That's the terminology that they use, and they have helpfully gone on to define what they judge to be effective participation. And really, given the requirements in the civil procedure rules for parties to assist in identifying vulnerabilities and also to assist the court to case manage cases justly, I would suggest that is a very effective and useful tool. So moving on to what the Equality and Human Rights Commission have defined what they believe effective participation to be. Well, they define effective participation as being when a defendant can explain their version of events, when the defendant can understand what they've alleged to have done, when they can understand the case and the evidence against them, when they can understand any defences and options available to them, and when they can understand written communication or can be assisted to understand it. They'll obviously be written to by the court, sent court orders, directions, things like that. They may also be given copies of court orders afterwards. They also judge that effective participation is when a defendant has a general overall understanding of the trial process, when a defendant can give their best evidence, when a defendant understands the significance of any penalties that they face. That is obviously vital, and that feeds quite nicely into somebody's capacity, for example, to understand and comply with the terms of an injunction order and understanding consequences of breach, etc. The defendant understands the requirements of out-of-court disposals, so that for our purposes would be any negotiated settlements. So the terms of any suspended possession order, for example, or any adjournments on terms. Does the defendant really understand what they're required to do to comply with those? And really the benefits of all of those will reduce the possibility of appeals and orders to set aside. And that, I think, really will benefit all parties to litigation, not just the defendant, in my view, because having witnesses and victims who've gone all the way through court proceedings and believe that they've been concluded, only for them to be appealed because of any potential vulnerabilities that may have been missed or any alleged unfairness in court proceedings, doesn't benefit anybody. And really the overall idea of litigation and trials is that after the events, there is a definite outcome for everybody who's affected, and that allows people to move on. So I wanted to look at a case study of special measures, given that we've touched on that. And this was a case I had conduct of. It's about 7 or 8 years ago now. And there were allegations, a long history actually, of allegations of antisocial behaviour against a particular defendant. The housing provider had followed the policy to the letter. They'd tried tenancy warnings, the behaviour escalated. They then obtained an injunction. The behaviour continued and escalated further, so they issued committal proceedings. And then when the behaviour got even worse, they then issued possession proceedings. And as I say, there was a long history of abusive and threatening behaviour. One neighbour in particular was targeted by this defendant, including her family, one of whom was her son. He was 17. He was autistic and had some learning difficulties. And the son was the victim of antisocial behaviour in a local shop when the defendant spotted him. And she was actually caught approaching the witness on the shop CCTV, although unfortunately there was no sound, but she could be seen approaching him. And that corroborated his version of events. The witness reported that threats had been made to him by the defendant. And those threats were designed to frighten the witness about the case being taken against her and the case being taken forward by his family. There were some allegations that very insulting remarks were made about the learning difficulties that the witness suffered from, and they were very upsetting and embarrassing to him. And all of those circumstances made the witness feel very worried and anxious about seeing the defendant. He really didn't feel as though he could stand up in court in the witness box in the traditional way and give evidence face to face while looking at the defendant. We spoke to the witness's doctor, and we got medical evidence about the various conditions that he suffered from. And we also asked the doctor to give an opinion in relation to giving evidence in court in front of the defendant. And that then supported our application for special measures, which was considered at a directions hearing. So the judge, when considering our application for special measures, he balanced the witnesses' vulnerabilities and all of the things we've already talked about at the beginning of the session versus the defendant's right to a fair trial. The court will always undertake that sort of balancing act. And the judge came down in favour of the witness being given permission to give evidence by way of special measures. And because of the anxiety that we were able to demonstrate that the witness was suffering from, the witness was actually given permission by the court to have a separate entry and exit into the courtroom. And I have to say that's the one and only time I've ever been allowed to accompany anybody, including a witness, via the judge's entrance to and from court. We entered the court via a back room, and the witness did not have to see the defendant at all. Also, due to his anxiety, he was given permission to visit the court the day before and familiarise himself with the layout of the courtroom. That was really very useful and put the witness's mind at rest. We followed the route that we were going to take in and out of court. The screens had been set up. I was just going to come on to who's given permission to give evidence behind a screen, so that the witness really knew what they were doing on the day. And in relation to the outcome, well, after the witness gave his evidence and the other evidence was heard, the defendant was found to have breached the injunction order. An outright possession order was made in respect of her property. And the witness and his mother in particular were really very grateful. The witness commented that he felt as though he'd been really listened to and been believed. And afterwards, we took the time to speak to the witness. We explained the value and importance of his evidence. And I genuinely felt as though the witness and his mother felt as though justice had been done that day. And that was really quite something to be part of. So that's as much as I was going to say on vulnerable witnesses, victims, and special measures. I wanted to open this up now so that people could share experiences and or ask questions. I know that we often, when we're speaking to witnesses, allude to special measures. I was just interested to put the question out there to you all and ask if you've got any experiences of that, if you have any cases at the moment where that is something that you're looking at and or you think you might want to consider. Whether you've asked for special measures and the court has said no, or they've made some amendments to your requests. I'd be really interested to hear. I can see there's some comments in the chat box, so I will just have a look at those before I wait for any questions to come in. Oh, you're all a polite bunch. I think you're all just saying good morning. Just so that people are aware, we will make these slides available. Oh, we've got a question. Okay, so what form does an application for special measures take? And that's from Jackie Allen. Morning, Jackie. That will really depend on the stage in proceedings that you're at. So if you're at a directions hearing or a case management conference, you could raise it orally there. Yourself or your solicitor could do that. If you become aware of, you might have a directions questionnaire as well, which is sometimes sent out. The courts do dispense with them sometimes, depending on the types of proceedings that you're in, but you will be asked on that form if you've got any, if you need any special measures. It might be that you become aware of something partway through proceedings or a new witness comes on board. And in that instance, I would just do your application on your usual N244, so your standard application form, backed up by witness evidence and or medical evidence where appropriate, just explaining what the special measures are that you're asking for and why. I've got a question from Joe Sylvester. If someone has literacy needs, does the witness statement need to be adapted to make it clear around this? For example, they have to read it and sign it to say they're making a true and accurate record. That will depend, Joe, I would suggest, on what the literacy needs are. So it might be that this person has a support worker or an advocate that can help them. It may be, as we alluded to on the slide, if it's not a defendant, if it's a witness, it might be that the court decides they need a legal representative or somebody else appointed to help them and to support them. But the key thing is that the person can understand what's being said. If it's a defendant, it might well be that the solicitor can help them or they can signpost them to relevant agencies. The key thing is that the person can participate effectively, which was on the slides that we talked about from the Equality and Human Rights Commission, and that any vulnerabilities that they suffer from don't then become an obstacle and a barrier from that person taking part in proceedings as anybody else would. I've got another one from Stephen Horton. Morning, Stephen. It's common I find witnesses to say they can't attend court due to mobility issues. A recent case, this was used, then she casually told me she'd be in Australia at the time of the trial when I offered a taxi. That would be an expensive taxi anyway. Do we need to be far clearer now that judges could be as harsh about defendants on appearance without exceptional reasons as witnesses, and it can sway a case? Well, if a defendant can't attend a trial, Stephen, then it's really on them, isn't it, to explain to the court why and to give a good reason. I mean, depending on the sort of proceedings that they are, if a defendant doesn't attend, for an example, a return hearing for an injunction, I'd fully expect the order to be made against them. Similarly, if they didn't attend a possession trial, for example, and there's no good reason for attendance, I'd be expecting orders to be made against them. The onus then is put on the defendant. They have to make an application for an order to set aside any orders made against them. And as part of that, under the civil procedure rules, they have to show there's a good reason why they didn't attend. And just saying, oh, I was in Australia without any proof of flights and accommodation, things booked in the name, and or doctor's letters, hospital admissions forms, for example, I would expect the court to take a really dim view of that, to be honest. And that's a really good question, Deborah Shaw. How do we help a witness identify what special measures they might want to ask for? What's available? Well, really, Deborah, that will depend on what the witness's circumstances are. I mean, it's a really good question because it's quite a delicate subject to have to broach with somebody, I suppose. I think the way I would phrase it would be to ask them what this person needs to make them feel as comfortable as they need to be, to give their evidence in an appropriate way. So, as I say, we can, the court will put screens up, the court will allow evidence by video link. I've had adjustments made for people with hearing impairments. For people who are visually impaired, things can be put in braille, they can be translated. I alluded to mobility issues where the proceedings were moved to a much larger courtroom with double doors to the entrance, and as I say, much larger, so that even around the advocates' benches and moving around the courtroom into the witness box, that was doable in a wheelchair. You may need to make a bit of a value judgment yourself and then just suggest that there are things that can be done. What we wouldn't want is somebody turning up to court feeling uncomfortable. I feel as though they're at a disadvantage before they've even started giving evidence. I mean, you'll know yourselves, those of you that give evidence in court, it's a pretty stressful thing anyway. And you know, you guys are used to it, you're professionals. So when we're asking witnesses and defendants who may not do that as regularly or may not have done it before, it's really important that it's as the daunting aspect of it is reduced, if I can put it like that. So, question from Lucy. Morning, Lucy. Who's responsible for introducing special measures for victims? Is it the police, support workers, solicitors? I've found that special measures almost always seem to be a last-minute thought or suggestion. And if it's mentioned too late, the witness has already been lost and scared off from supporting a case. Well, Lucy, that will depend on, I suppose, who the first contact is with the witness. So if you're talking about witnesses in your civil cases, your housing cases, really when you're speaking to the witness and gathering evidence, I would urge you to introduce this idea to them of special measures and explain that it's to assist people who don't feel able, for whatever reason, perhaps that's the way to phrase it, to give evidence in the traditional sense, standing in a courtroom in front of a defendant. And as I say, it may be if there's some physical disability that's immediately apparent to you, you can make suggestions to the witness that way. If there are mental health conditions, it may be that you want to ask the witness. But it's certainly something that you as the claimant and as the housing provider could and should raise as early as possible. If it's something from the defendant's side, again, that really should be something, if there are legal representatives involved, that's raised at any case management. It may be that if they come on board duty solicitor at a first hearing and they want to consider that, then you may want a case management conference to look at that. But these should be things that parties, yourselves as housing providers, once you're aware of it, obviously if you feed that information into your legal team, they should be raising that for you, and the defence should be raising that as soon as possible. It shouldn't be something that's raised last minute, unless the vulnerability becomes apparent last minute. If somebody's had an accident recently, for example, or something like that, or has become very unwell, you certainly shouldn't be reaching a week or two before proceedings and then having to worry about whether things are adjourned. Obviously that there are cases where that can't be helped, but really good case management should allow you to address that earlier. Okay, I've got a question from Emily. Morning, Emily. would alcoholism or substance misuse count as a vulnerability if it's been previously documented in the received treatment, both for victim and perpetrator? That's a really good question, Emily. It's something that we see a lot in relation to our cases, alcohol and substance abuse alongside mental health. That would very much depend on the extent of the issue that the person is suffering from. So, for example, if somebody turned up to court drunk, the court wouldn't allow them to give evidence. They wouldn't be mentally capable to be able to do that. If somebody is suffering from health implications as a result of this substance or alcohol abuse, and I mean, you can have alcohol-related brain injuries and things like that, then that would be something that would need to be considered. But you'd really need to look at the extent of the substance and alcohol abuse and what the long-lasting impacts have been. A question from Kaylee. Morning, Kaylee. In regards to effective participation, the HRC guidelines you mentioned, would this be used to determine capacity to litigate, or is it just used to determine special measures? That's a really good question, Kaylee. As I said, it actually looked at criminal proceedings. But for me, there were a lot of echoes with questions that are often asked by medical experts and psychiatrists when they look at a person's capacity to litigate. So for me, that they are questions really that as housing providers, as claimants, you should be asking yourselves in relation to vulnerability. I think that as I say, there are a lot of mirrors with the two of them, which why I thought it was very useful for today's purposes. I got a question from Simon. Morning, Simon. Are the guidelines in particular around alcohol use, where we tend to try and arrange meetings earlier in the day? If we were given an afternoon hearing, would we be able to ask for it to be moved earlier to allow them to give better evidence? That is something, Simon, that if you thought the alcohol addiction was so severe and you knew there was a certain time of day where you were likely to catch the person to be compos mentis, to be sober, that is something that you might want to think about. Hopefully you'd be able to discuss that with the person's solicitor. I'm presuming that if it's a defendant, if it's one of your witnesses and you've got a day's trial, I'd always remind you that you have the autonomy in terms of the order in which you call your witnesses. So, for example, I had a single parent witness who had to be called on first because they had to be released from court before 2 o'clock to go and pick the child up from school. So we, as a claimant, you run your case in the way you see fit. And if you explain to the judge, I'm calling this witness first because of X, Y, Z, I'm sure that would be fine. That will depend again on the circumstances of the case. I'm aware of some witnesses and defendants who abuse drugs and alcohol who you wouldn't be able to get up before 11 o'clock in the morning. So if you wanted them to come to court, you'd be better off asking them to come at 2. So that will depend on your case and the specifics of it. I've got a question from Jonathan Barrett. Morning, Jonathan. I've recently last month had a case where a defendant was vulnerable due to mental health issues. We ended up having screens in place so the victims couldn't see her. I think they were grateful for that, as was the defendant. That's a really useful comment. Thank you, Jonathan. I think, yeah, the screens can work both ways actually as well, which was why I wanted to include vulnerable defendants in this. You know, the vulnerability aspect of it should be considered in the round, and you should be looking at everybody and how they can participate in proceedings, not just your victims, not just your other witnesses who are corroborating what the victims are saying, but also the defendants as well. So thank you, that's really useful. And I've got a question, do we have a sample copy of a typical vulnerability review that we could send out? I've suggested that they're done alongside your typical Equality Act reviews, because I think anything or most things that are going to affect somebody's vulnerability will be picked up in one of your EA reviews. I would also look at any information that you've got on your tenancy file, any information that you've got on your sign-up forms. But if you use your Equality Act reviews, I think you're probably along the right lines there. I think that is all of the questions so far. I will just go on the chat box and see if I've missed anything. Here we go. Got some other things here. Okay, so Jane, Windsor in Birmingham, you've got to give a lot of notice to the courts if you ask for special measures. Well, Birmingham's pretty big, isn't it? So, and Manchester's my local court, and that is the same. That probably, I imagine, is due to listing, and just the issues that they have with the volume of work that they've got. But at the end of the day, if you need your special measures, you need your special measures, don't you? So the court really should accommodate them. Steve Burgess, bearing in mind how difficult it is to get hold of the London courts, what's the best way to draw their attention to the request? I feel your pain when it comes to getting hold of London courts, to be honest with you. I think put your request in writing, put it in writing again, and it may be that you have to make an application and pay the fee, because then it will have to be listed. I know it's not ideal, but if you get, particularly if you can get the other side to agree and you're only paying a consent fee of, I think, £110, that may well be money well spent, rather than accruing costs and accruing potentially legal costs of your solicitors just chasing and chasing and chasing. You issue an application, they've got to deal with it. So that might be the way, the quickest way to do it. Gemma, so in relation to applying for special measures within a certain time frame, well, the witness wouldn't be able to ask for a screen on the day purely because of the logistics of it, and it might be that all of the screens that the court has are in use elsewhere. So we really would need to be thinking about that a little bit beforehand. Obviously, as I said, there are always going to be exceptions where something happens the night before, the morning of the hearing, for example. Under those circumstances, it might be that you need to get an adjournment, but this should be, the witness would need to be, and the defendant and or the victim would need to be made aware that this is something that would need to be. There isn't an infinite number of screens, etc. If somebody wants to do it by video link, we couldn't just, magic that up on the day. So we would need, because of the logistics of it, the courts would need some notice. I'll just check if there's anything else before I bring things to a close. I think that we've addressed everything. That was really great. Thank you so much, everybody. 1 for attending and 2 for sharing your experiences. As I say, this is always something, ideas, I think, vulnerability, special measures, we sort of float around and we discuss and we offer. But actually, when it comes to putting it into practice, it's not always something that's perhaps as common as we first think. So, as I say, I think I can count on 2 hands, and I'm 15 years qualified. I can count on 2 hands the number of times I've actually used special measures in cases. So I think that demonstrates that it's relatively rare. I think that is everything. As I say, we will be doing some new sessions, and we'll be starting to market those. I think we'll start from April. So if there is nothing else, I will bid everybody a good day, and I will leave my contact details there. If I can help with anything, please do get in touch, and have a good day.